Good evening, ladies and gentlemen. Thank you so much for joining us for tonight's edition of HR Mentorship Learning Series. Tonight, the topic we'll be looking at is industrial disputes, termination, suspension during resignation, and probation extension. The topic sounds like a mouthful. Ladies and gentlemen, our facilitator for today is Paul Okeshino, and I'm happy to say he's not a first timer. I think this is the second or third, if not more, time sharing insights and knowledge with us. Ladies and gentlemen, Paul Okeshino is a highly accomplished senior human resource business partner with over 7 years of experience spanning the insurance, financial services, and financial technology industries. Throughout his career, Paul has championed key HR initiatives, including graduate training programs, manpower planning, policy writing, integration and implementation, business expansion, performance management, and organizational design. Currently, he is driving strategic people initiative. Paul is also known for his practical approach to aligning HR practices with business growth objectives. He attended the best university in Nigeria, that is the University of Ilorin, where he bagged his bachelor's degree in business administration. He also has a master's degree in industrial and labor relations from also a very great university, University of Lagos, Lagoon Front. Paul brings a dynamic and insightful perspective to every engagement with a strong passion for building sustainable talent pipelines and fostering performance cultures. Tonight, speaking on the topic, industrial disputes, termination, suspension during probation and probation extension, I present to us Paul Okeshino. Over to you, my brother. You need to unmute. I hope somebody has not suspended Paul's voice because he needs to unmute. They have followed Paul to this place.
Welcome to the presentation. My name is Paul Ukeshino, and we'll be discussing about industrial disputes, termination, suspension during resignation, and also extension of probation. This conversation, of course, would be a discussion, and of course, no man is an island of knowledge. We'll be sharing insights, understanding, and we'll be looking at the labor law. We'll also be looking at the precedents in the National Industrial Court. Also, we'll be looking at ILO, looking at other precedents that must have occurred over time that surrounds employment in Nigeria. So I would want you to sit back, relax while we dive into this discussion. And of course, I would expect that participants are able to come up with viable questions right at the end of this conversation. Speaking to it, it's more of the same we have in employment in Nigeria. And I, for one, would like to say that employment in Nigeria nowadays has become a case of anyhowness, where even we as HR professionals are not taking due procedures, listening to what the CEO or business owners would want to instigate on employees. And it is imperative for us to understand the principles, understand the law, the terms that surround employment in Nigeria. And the major cause would surround termination, dismissal, unlawful termination, and also the new case that has just been released by the Industrial Court based on probation and also extension of confirmation. Ladies and gentlemen, moving on, let's look at our presentation for today, table of content. We'll be looking at the introduction. We'll also be looking at termination of employment, reasons for termination of employment, suspension, summary dismissal, difference between termination and dismissal as a whole, extension of probation, and also lastly, we'll be looking at employment laws in Nigeria. We'll be looking at definition of terms of what you see right there at the table of content. So in Nigeria, as an employer, laying off employees without due procedures is unlawful, and it is important for us to place the procedures accordingly as stated in the terms of contract under the labor law, section 9, stating how a contract should flow. However, it's also a complex framework as the labor law has not shown clarity in majority of the issues that will surround employment in Nigeria as of today. So majority of the time, we tend to fall back to the precedents in the court of law, in industrial court, Supreme Court, Court of Appeal, to see the various ways whereby we can improve our understanding on the laws that guide employment in Nigeria. So as HR professional, it's also imperative that you understand the principle because it's crucial for your success in terms of your career. And over time, I would say that as an HR manager, HR business partner, HR officer, it's also imperative for you to understand the law. You need to have it handy so that to process some certain things that surround employment in Nigeria. I also feel that the major reasons we do not have much litigation, although it's increasing day by day over time, is on the basis of employees not understanding or they are unfamiliar with the laws that governs employment in Nigeria. So that's why we find ourselves in a place whereby we can, terminate employment without reasons, without procedures, without what is stated in the contract of employment, without what is stated in HR policy or what we call the employee handbook. So today's conversation would surround this framework and would be looking at it from different points of views. We'll be looking at it from different precedents in the court of law. We'll be looking at what the judgment has said over time, how we can also go back to our policies and improve all these intricacies that might have been mentioned today. So today in the world of legal space, it's evolving and involves legal practitioners. So it's very, very important for us to see how we can, resolve major issues before filing litigations. We see employee filing litigations thereabout. So let's look at concepts. Let's look at definition of terms. Let's look at termination as a whole. Termination would refer to ending an employee service that is bringing an employment relationship to a close. This can happen voluntarily or involuntarily. On the side of the employee, it will look like a resignation. And of course, the terms within the employment must be clear, there must be clarity, it must be stated explicitly. And it's important for us to also note and also refer back to what we have in our HR policy. So under the Labor Law Act, Section 11, thereabout, speaks about the notice period we need to give to employees, which global standard will be looking at 1 month in lieu of resignation and also a notice period vis-a-vis both the employer and the employee. So similarly, these common law principles that both employer and the employee have the right to end employment relationship, provided that they adhere to the clause and to the laws that surrounds the written contract the employee must have. Also, adding to this, I would also want to state that reasons for termination must be stated clearly. And that is where we'll be going through in our next slide to see the reasons for termination. Employers are obligated to provide a valid reason for termination. Terminating an employment contract, failure to do so may result to or in termination be deemed wrongfully. Case study would be Eberichi Onyekachi versus Diamond Bank and also Jury versus Skybank. And we've been able to see one of the various reasons while terminating as an employer. And we'll be looking at the number one we have on our screen, which is redundancy, which means that the role is no longer surplus to requirements in the organization, and there's more manpower in the environment, which would also look at downsizing, restructuring, and also diminished need of that position. Take a case study of Heritage Bank. Their license were revoked by CBN, meaning that the whole organization is redundant as a whole, and termination of employment would surround redundancy or closure of business. You'd also look at businesses or organizations that would stream from the northern part or the eastern part of the country where insurgency has taken place, and hence the branch needs to close down. Also, there might be reasons for termination of employment based on redundancy. Section 20 under the Labor Law Act 1, 2, and 3, especially Section 3 of that Labor Law Act, explain explicitly redundancy as a whole, and it defines it as involuntary and permanent loss of employment resulting to surplus manpower. We'll be looking at misconduct also, which would surround your code of conduct, disciplinary action, disciplinary steps. So these include violation of company rules, theft, insubordination, harassment, and also violence or other serious breaches of contract. This is where it's very important as an HR professional to understand the nitty-gritty, the procedures whereby you terminate an employment based on gross misconduct or misconduct within your organization. And in most sanction grid or disciplinary action I've seen thus far, it would start with probably a fair hearing, which the industrial court has also mentioned over time that it's important to give the right of the employee to speak to what has happened over time. And needless to say that querying an employee is also a means of fair hearing. And we've seen so many times where HR would say query is more like a warning. Query is not a warning. However, query is a means of fair hearing, where you ask what happened, why, stating the date of the issues that might have surround the cause of the misconduct such employee has, been into. So you see cases of theft majorly, which should be naturally a dismissal. We see cases of insubordination, harassment, looking at bullying, sexual harassment, cases of violence, and also breaches on the code of conduct that surrounds the organization. And it's important for us to put a disciplinary code, also a disciplinary committee to sit on every matter that surrounds gross misconduct, because the labor law or the National Industrial Court, while filing a litigation, must have a disciplinary hearing of what transpired, the decision they made. And over time, setting up a disciplinary committee must be odd. That is, must be in odd numbers, not even, so as to have a two-third numbers of votes in terms of the decision they would like to make. Moving on, we'll look at more reasons why involuntary termination of employment. We look at performance. This means that failure to meet job expectation or consistent poor work quality or unsatisfactory performance can also lead to grounds for termination. So what it means is that for every situation that surrounds performance in your organization, it must be well documented. So performance appraisal over time must be communicated to staff. Maybe the staff is under mediocre, or let's say a poor performer within the organization below 44 downwards. There must be communication. And at a point whereby you've done performance appraisal, you don't necessarily go on to terminate such employment. The industrial court also mentioned that there must be room for improvement of performance. And that's where you see what we know as PIP, which will surround maybe 3 months or 6 months to see if there any room for improvement of such employee. Also, this must be communicated in your termination of employment. It must be well written, stated clearly the reason why such employment is being terminated within your organization. Failure to do such means that you are creating room for litigation, which has also been stated by the National Industrial Court, also looking at the ILO termination based on a recommendation of 116, which the court recognized that certain international best practices for employment termination. So you would want to see it is now contrary to industrial labor standard and international best practices, and therefore unfair for an employer to terminate the employment of its employee without any reason or justifiable reason that is connected with the performance of such employee. So I'd like to advise us as we terminate employment to always state the reasons for termination in a termination of employment. So employers are required to adhere to standards specifically based on Article 4 of ILA, which states that the employment of a worker shall not be terminated unless there is a valid reason for such termination connected with the capacity or conduct of the worker or based on the operational requirement of undertaking establishment or services. So those are major reasons why you want to terminate employment involuntarily within your organization. First and foremost, we spoke about performance, we spoke about misconduct, and we spoke about redundancy. So let's move on to see the procedures of termination, what we need to do as HR professional. First, we need to put a notice for due process and to consider the following termination employment contract. Employer must provide adequate notice to employer in terms of terminating employment contract without prior notice constitutes wrongful dismissal. Also, you need to investigate, you need to do your research, you need to make your findings. So if an employee is accused of misconduct, investigation should be conducted immediately, and evidence of such misconduct must be presented to the employee, informing the employee of the situation at hand. And also the employee must go through what we call fair hearing to review the situations. Like stated previously, we also need to look at the reasons for termination of such employment, where the Industrial Court of Nigeria has consistently held that it is in line with international standard and best practices for an employer to provide a clear, cogent reason for dismissing an employee. This reason must be given with valid and substantiated proof. Also, fair hearing. The law prohibits any form of jungle justice. Employee has the fundamental right to fair hearing before any decision can be made based on their termination. This is the cornerstone of fairness and, of course, also justice. So in all that is being said on the termination, apart from resignation of employment from the employer, it is important for you to follow due process. By no means should you take out what you have in your processes within your organization, looking at what you have in your HR policy, employee handbook, or what is stated within the termination of employment that surrounds the offer letter you've given to such employee. Majority would interface with, let's say, a 1 month notice, unconfirmed, maybe 2-week notice, as it is best practice and global standard. So let's move more. Let's look at suspension in Nigeria. And this situation has become something important for us to understand. In the context of law in Nigeria, suspension means that it's a temporary removal of employment, not outright removal as far as dismissal has not been served. So regular duties pending an investigation or disciplinary hearing must be conducted during suspension. And also it is imperative for us to make sure that we close suspension, we investigate as soon as possible, because even the labor law and also the National Industrial Court frowns at lengthy suspension. And when suspension becomes prolonged, there's room for litigation. Then such is not good within your environment. So let's look at types of suspension that you would have in every environment. Suspension with pay. In major cases, you would find in the industrial courts, it's been stated that during this type of suspension, the employee continues to receive their salary and benefit. So should you suspend without pay, that means you have it written in your employee handbook, in your HR policy, or stated on the terms of employment of such individual. There was nowhere in the National Industrial Court of Nigeria where suspension without pay was agreed on, especially on the basis where it is not stated in any of your policy, any of your documents, any of your code of conduct, or disciplinary action. And it's written as unlawful to suspend an employee without pay, unless, again, written in the terms of employment. Should you not have it in your terms of employment policies, then the National Industrial Court frowns at suspension without pay. So in this case, the employee is not entitled to receive any salary or any benefits. So it's imperative for us to look at these guidelines so as not to make sure that we go on to the industrial court, filing litigations, trying to resolve issues that should have been, taken out from the root cause, from the origin itself. So let's look at the rights of employee under suspension. The number one right every employee would have when it surrounds to termination, suspension, dismissal is right to fair hearing. At no point should you terminate an employment, dismiss an employee without hearing the other side of the story. Although you have clear evidence of the situation, however, based on NICN again, it is important for you to set up a disciplinary committee to listen to whatever the employee would have to say. Then if the conversation is not justifiable, then you can go on to dismiss or terminate such employment. So in Olatubosun versus NISER Council, the Supreme Court highlighted the significance of fair hearing in employees' dispute. The court ruled that an employee must be provided with sufficient notice of allegation against them and must be given a fair opportunity to defend themselves before any disciplinary action is taken. Again, before any disciplinary action is taken, you must hear them out. That will start from a query is a means of fair hearing. This principle reinforces the needs for due process in employment-related matters. When you take fair hearing from a disciplinary process, then there's room for litigation, and the National Industrial Court frowns at it. Right to be informed of the offense. In Shell Petroleum Development Co. Limited versus Victor Sunday Olariwaju, the Supreme Court emphasizes the importance of informing an employee on the allegation against them. So they need to be well aware of the situation, not hearing from others employee that something happened, you did this, you did that. They need to be communicated. So this will enable the employee to adequately prepare their defense, ensure fair and just process in the disciplinary procedures. Let's look at rights to representation, especially when it's an internal disciplinary proceedings. Of course, such employee has the right to defend him or herself. However, employees under suspension are entitled to be represented during proceedings, either in the court of law or external proceedings, where the allegations are serious and the employee lacks the expertise to adequately defend themselves. So representation can be a legal practitioner, a union representative, or any individual of employee choice, as it's case in the Shell Petroleum Development Company versus Lawson Jack. The court appeal reinforced the importance of providing employees with the opportunity to represent during disciplinary action. Moving on to other rights of an employee under suspension, right to be paid during suspension. Again, right to be paid during suspension. And this would look at the case study or the precedent Longe versus First Bank of Nigeria, where the Supreme Court held that unless there is a clear provision in the contract of employment, it's non-negotiable, it's not debatable. Unless it's stated in your contract of employment, should you suspend an employee without pay? So if you have been suspending an employee and you've not remitted pay without this not being in their contract of employment, then you are wrongfully flouting the process, as the case may be in industrial court. And the funny thing about this is because employees do not understand the law. Employees themselves are ignorant of the law. They've not understudied the law to a certain percentage to know their rights. I still feel that if employees know their rights, I feel that HR professionals in Nigeria would sit up in terms of the procedures they've created within an environment. And in most cases, you would see CEO advising you as an HR to terminate an employment, and you as an HR, you still go ahead to terminate such employment without reason. You would see the recent case we have on LinkedIn where a lady was terminated because she didn't pick the CEO's call, and hence she was advised to resign immediately because she was unable to pick the call of the CEO. And during further investigation, it was being noted that the call came in maybe over the weekend, and she was advised to come in on Monday and, of course, put in her resignation. And, of course, it's no longer news. That news is everywhere on LinkedIn, and people are looking at what the decision would be over time. We look at the judgment of AFBAT, judgment number 72, which tribunal ruled that suspending an employee without pay is unlawful. When the employment contract did not, again, explicitly permit such action, the tribunal further stated that unless there is a clear evidence of gross misconduct justifying suspension without pay, the employee should continue to receive their salary during suspension period. And lastly, let's look at reinstatement and compensation. An employee exonerated on the allegation must be reinstated to the organization, and sometimes or over time see a situation whereby the industrial court will also give room for more damages to be paid back to such employee because it was not treated well, and of course must be paid damages. You'll see case study of Mobile Producing Nigeria versus Udom Tom in the Court of Appeal, where it granted damages and back pay to an employee who was unjustly suspended, and also employer acted arbitrarily by suspending the employee without pay and without clear evidence of misconduct. So it is imperative for us and an HR to do our investigation when we do not have clear-cut understanding of what transpired. I would advise that you look at the situation inwardly and to find a resolution on the case. Because when you say you're suspending an employee on the case of theft, that's damages already. That's profile damaging. The employees are sure to go back to the organization, and hence, before we declare anything, we must be correct in whatever decision we have to make as HR professionals. Let's look at other rights of an employee. Duration of suspension. The duration of suspension is key aspect to employment law, and it specifically doesn't state the maximum time. However, the Court of Appeal held that an unduly prolonged suspension is unlawful, especially when there's too much back and forth. The organization is not trying as much as possible to investigate the matter, to carry the civil institution along, the police, the court along on their investigation. Then it becomes a prolonged suspension. I would, for one, would say that suspension would literally not be, if you go on to do your thorough investigation, should not go more than 2 weeks for you to conclude on your decision for that employee. And main focus, resignation during suspension. All employees have the right to resign at any given time. Hence, the judgment by the NICN has established that employer has the right to resign during suspension, as long as the resignation is not forced or coerced. And you see the case study of Kogi State Polytechnic versus Ogungbemi 2014, where the NICN ruled that an employee under suspension could validly resign. So it means that an employee can resign within your establishment, but you can still further go on with your investigation. All you just have to do is to file your litigation and request for damages or for refund if it's theft or brand damage, etc. So therefore, employees may resign during suspension, but the resignation must be voluntarily. It must not be forced or coerced by any participant within the organization. So those are the rights of an employee that we have under the law, and it's imperative for you to understand these rights so as to make sure of how you can make your suspension very short, the investigation process, the decision, disciplinary committee, the code of conduct, and also your investigation as a whole. Moving on, let's see other means of termination, which has also been said to be a dismissal. Dismissing an employee in an environment is on the basis of gross misconduct. That is, something has happened. After you must have investigated the situation, it is imperative for you to now decide. In majority of the policy I've written over time, it must follow what we call a step, right? And for termination or for, let's say, misconduct that is not major, that is minor misconduct, like lateness to work, they would surround like first warning, final warning, then dismissal, right? But dismissal on its own case would focus majorly on gross misconduct, which has been explained to be theft, harassment, bullying, sexual harassment, so on and so forth, within what you've written to be as gross misconduct in your HR policy or in your HR manual. At no point in time must you go overboard. So if something is not stated clearly in your manual, that means it's not clear. That means you can't make any decision that surrounds it. So it's important for you to understand the framework, as dismissal means that you are terminating the employment effective immediately, right? Without notice or payment in lieu due to gross misconduct. However, I've written some policies that would state that should be the gross misconduct be a little bit minimal, not theft. Employees might be paid the total number of days they've worked within your establishment. So all this must be stated in your policy before initiating, right? Misconduct can be severe, that is, undermines the core element of employment contract, effectively breaching its essential provisions. So when an employee breaches your code of conduct, that is what is expected of an employee within your environment, then when it's a major case, then it's important for you to investigate, give a fair hearing, and whatever decision the disciplinary committee must have made must be communicated to the staff. And I've seen dismissal letter to be, dear John, you are hereby dismissed effective immediately. The reasons of that dismissal must be stated in your dismissal letter, right? So you are not dismissing based on a blank page. Why did you dismiss such employee? And one of the things I've seen in a termination letter, it doesn't have, let's say, time lapse. That is, um, um, st- uh, I'm talking about something that has happened in the past. You need to state it from the origin. Dear John, you sequel to our investigation on 24th April 2018, you did so. Next paragraph. Also, during our investigation, we've been able to see that on the 30th of so, you've been, let's say, going by illegal theft within the company. So all these things must be stated in the letter. Else, you are creating room for litigation within your environment. And for you as an HR professional, HR manager, you are an advisory person to the organization. It's your duty to advise. And I've seen cases whereby you advise, but the owner of the business will still go on for you to, okay, I still want this person to be terminated immediately. Please document your advisory, your comments, so that when it bounces back, you have evidence or clear evidence of your advice to the management on the basis or the reasons why you do not support the unlawful termination by the top level management. So you as an HR must be very, very prudent, very, 100% at what you do in terms of documentation, right? And you must put necessary party in copy of your decision as an HR manager to the top level management. And you must also state the litigation that surrounds the unlawful termination of such individual within your establishment. You can quote cases on the Nigeria National Industrial Court of Nigeria. You can quote Supreme Court. You can quote the labor law. As far as you are going through the right process, that would, vindicate you since they've made within the organization. Let's look at the difference between termination and dismissal. They are not the same, right? And previously we've spoken about termination, where we have voluntary and involuntary termination. This is the right enjoyed by both employer and employee. However, dismissal, this is the sole right of an employer after proper investigation must have been made, right? Termination will also be looked at is period specified in the employment of contract. So employment of contract based on section 11, right, of the labor law. You also look at section 9 of the labor law, stating how a contract must be designed. It's there for us to use, right? So there are cases whereby in the section 11 where it states that when an employee uses a week, such person can terminate the employment effective immediately. When an employee uses 2 weeks, such individual can give 1 week notice or 3 days notice. Where such an employee has used more than 6 months, can give 2 weeks notice or still under confirmation. But where an employee is more than 2 years, a year, would have to give 1 month notice period. However, for dismissal, this is done instantly, as you wouldn't want to have such individual within your environment after proper investigation, which would also look at the risk of having such individual in your environment. Disciplinary procedure must also take place within this conversation. Upon termination, certain benefits may be accrued to an employee, such as gratuity, leave allowance, and other benefits that surrounds the contract of employment. However, for dismissal, this terminate the employment and may leave room for no entitlement or benefit. Where termination is without notice, the employee is entitled to his or her salary in lieu, right? So when you terminate an employment, based on your contract of employment, you have to pay a 1 month salary in lieu and other benefits that surround such employment. However, for dismissal, there is no requirement or such notice of salary in lieu. However, an employee can be paid the total number of days he has worked for. The salary for the days he or she has worked for. Other benefits can't not go on to be paid. Let's look at extension of probation, which has been the new court ruling by industrial court. And this would be a situation of you going back to rewrite your policy on probationary period, right? If you say in your policy that your probationary period is 6 months, resultantly, what the law is stating that if such individual has underperformed, you are viable to terminate such employment effectively immediately, right? But should you have a situation whereby you are now extending the probation to maybe 3 months, 6 months, the National Industrial Court, under the ruling of Union Bank PLC and also Chiamaka versus Ati Industry, has instructed that such is unlawful, and you can go on to either confirm such employee or terminate such employment. So in the industrial court has ruled that there is no provision for extension of probation beyond what has been written in the terms of employment, right? So in written case, the court awarded damages against a firm for attempting to extend an employee probation period without clear contractual grounds or mutual agreement. So should you want to increase, let's say, a probationary period, it must be stated in your terms of employment. You have 6 month probationary period. However, should you not meet the preferred rating for performance, your probation might be extended. It must be stated clearly, and both parties must be signatory to that letter. So in the context of Nigerian Industrial Court of Nigeria, there have been several cases that clearly the issue of probation and consequences of unlawful extending them, right? So this is the problem. The problem is that you terminate the employment immediately. The problem also makes that you want to restart the recruitment process as soon as possible. And major roles that would focus on this would be sales representative. They will find one thing on this because their performance over time for that short period of time might not be palatable. So the NICN ruled that an employer cannot unilaterally extend the probationary period without the consent of the employee or without provision in the employment contract. The court held that the employer must neither confirm the employee after the probationary period or lawfully terminate their employment based on performance. Recall, we have termination based on performance, as we've spoken previously. You look at the case of Anne Chiamaka versus Ate Group, where Justice Arowo Shegbe ruled that Ate inclusion of a clause in the contract allowing for extension of probation was unlawful. Hereby extending the probation was deemed to be unlawful at the industrial court. This proceedings was seated, I think, about October 2024, and the publication is out there right at the NICN website for you to go on to read more about the situation. what precedents make is for us to have an understanding of the reasons why we need to change some policies. So there are so many policies that have gone back to change. Policies that will surround probation of extension, policies that will surround performance, policies that will surround performance improvement plan, policies that will surround gross misconduct also, suspension also, and also disciplinary action that surrounds employment in your establishment. So I, for one, would advise you to go back, look at this policy, look at the precedents that we've mentioned over time, look at what the labor law or the ILO or the NICN has stated for you to make good understanding and judgment in rewriting your policy. To climax this presentation, let's look at the employment law in Nigeria, what you can make use of. First is the Constitution of the Federal Republic of Nigeria as amended in 1999, which provides the fundamental framework, right, for employment rights and obligation. Also, you would want to look at the Labor Act, which regulates employment terms, conditions, and protection for workers' rights. Other acts agreed by the National Assembly, which include ECA Act 2010, Factory Act. For those of you who work as an HR in factories, you would want to make this act, and the National Minimum Wage Act, of course, as amended based on the new minimum wage that has been circulated, Industrial Training Fund Act, Pension Reform Act, Trade Dispute Act, NHIA Act, which surrounds HMO or health of an employee within your establishment, Trade Union Act, of course, if you are a unionized environment, and also Finance Act. You would also want to look at any documents you can lay on Discrimination Act, where you have discrimination within the environment, people who have rigorous health condition like HIV, hepatitis B, and so on. What does the law state? You would want to go on to investigate that before you make your judgment. Also, decision by the court of law, which I also would want to say that I use more often to make decisions that surround employment. Anytime I find myself in a place whereby I need to advise the organization on termination or dismissal of employment, I go back to see the precedents to read what the court has mentioned over time, which would give me more understanding of the next course of action, and to see the root cause itself. And lastly, you look at the ILO, which is the general standard, and of course the NICN, that is the Industrial National Court. Also look at ILO for investigation, for referencing, and also for understanding. One of the major issues I also observed over time is the fact that the labor law which surrounds employment in Nigeria is not explicit enough, and sometimes you need to refer back to the courts to see the judgment made on certain cases. You would want to use AI to investigate unlawful termination and so on, to see the cases that surround the relativity of what you have in your establishment, right? So ladies and gentlemen, I would like to say thank you for listening to my conversation. And I believe that we've been able to understand what surrounds employment, laws in Nigeria, precedents in the court of law, suspension as a whole, termination of employment, and dismissal of employment that we have in Nigeria. So my honorable doctor, over to you. Should we have any questions or addition or observation that we need to take?
Thank you so much. I'm tempted to say Barrister Paul. Ladies and gentlemen, this has been sweet and sharp. We would like to take comments, questions, contributions with respect to the subject matter. So if you would like to voice your questions or contributions, or you have a question directly related to the subject matter, you can either type it and drop it in the message section on Zoom platform here, or if you prefer to raise your hands, we will grant you permission to unmute and speak. I see a lot of people appreciating you in the comment section. Thank you so much. Very insightful, very rich, very practical. I'm trying to see if there are any hands up. Checking. You have a contribution, have a comment? Okay, good. I see 2 hands up already. Yes, let's go with Inedima first, then we go with my brother Waliu next.
Okay. Good evening, Dr. Oluyemi. It's Nene anyway. Thank
Good
you
evening.
again, Paul. That was a great job you've done for us this evening. So my question is on extension of probation. So what about in a case where the defined period of probation is not stated on either the contract or the handbook, but it is stated that, okay, the company will apply a discretionary approach to this? Please, how do we handle this? If maybe, I know that in some cases people do give 3 months, but I've also seen in some instances where they do not outrightly define the period of the extension of the probation. Please, how would one handle this if it becomes a case that the employee would be let go? Thank you.
Okay, thank you very much for that question. So like I stated clearly, one of the issues we have is clarity, explicit understanding of the law, right? So in major cases, what the law is stating is that should you extend a probationary period beyond 6 months, that means on the terms of employment, you must have stated it that probationary period, right? Which is a clause under terms of employment after like termination, before you get to termination in your contract of employment, or let's say in your HR policy. It must be stated on the total number of months you'd want to extend the probation of such employee, right? So the word your probationary period will be extended doesn't hold volume. You need to give a variance. You need to give total number of days. You need to state total number of months, right? If you look at the termination of employment, they've stated total number of weeks or months of salary in lieu, or you have to give to the organization for termination. So if you are extending a probation, that means by no means should the word 3 month extension of probation should be absent in your terms of employment. But if I want to, or the one I did myself, I didn't extend the probation, right? I just left it as 6 months. You must meet the threshold of your performance rating. So within 6 months, if you do not meet the threshold, then we can terminate such employment. Also, you would want to review our performance policy based on the ratings, right? So you would want to be lenient on the percentage you would be giving to someone joining your organization. For someone who is currently in your organization, of course, you would say below 40, right? For someone who just joined your organization, you can say below 35. This is just to give room for them not to be under the reasons why you will be terminating an employment. But in a nutshell, should you want to extend a probationary period, it must be stated clearly the total number of months that you would have. I hope I've answered your question.
Yes, thank you very much. Thank you.
Okay, let's quickly take Waliu, and then you can please check the chat box for different questions so that you can respond to them. Waliu, you have the floor, sir.
Good evening, Dr. Oluyemi Adeosun, and I also want to say thank you to the facilitator, that's Paul Okeshino, for the wonderful presentation on this employment law matters. I just quickly want to add something when it comes to those situations that could make it difficult for the employer to fulfill their obligations. One of such is force major. And the force major is not something that is anticipated, and it's not even stated in anyone's employment contract, but it happens. A typical example of force major is COVID-19, when most organizations could not fulfill their obligation to pay salaries. Some even went to as far as laying off their workers. However, a common way or a better way to have done that could have been the organization should come out and notify their employees their current situations, and then how why they are not able to fulfill their obligations. So in that case, if the employer we still have to resort to termination of employment of those employees, that could fall under termination by operation of the law. So in that is telling us that there are some instances that would warrant the employer to be unable to fulfill their obligations as stated in the employment contract. And the major of it, or the most critical of it, is the instance of force major. It is not anticipated, but it happens. And I think the Labor Act also makes provision for that too. So I just want to add this, and to also give kudos to the facilitator, because he has made us to learn, unlearn, and also to relearn. Thank you.
Thank you very much for that wonderful contribution. In the forces you mentioned under force majeure, you would look at what we call pestle analysis. These are factors that are beyond the business. And as you have mentioned, COVID-19, natural disaster, economic imbalance, and all the stuff. Some would also go to regulatory bodies revoking licenses under the CBN, NDIC, and so on. What is stating clearly is that the role is redundant, right? So the law, like you said, also gave room for severance pay, or what we call redundancy payment to the employees. You look at the case study of Heritage Bank, Nigeria. You can also use AI to see the situation, how it was being handled. Another case study you'd also want to put into cognition is the case of the over 20,000 employees that were terminated in UBA in 2020, right? They had to say they were downsizing, right? As far as you follow due procedure, and your litigation might be minimal, right? But in termination, in dismissal, there's always a loophole somewhere that an employee can file litigation in the court of law, and also which dampens the image of the HR and also the organization as a whole. Thank you. Any further question?
So, Paul, please check the questions in the chat box, especially
Okay.
questions that you've not expressly treated. You will see one or two, you will know that maybe the person joined late. The person can watch the video again because you don't have time for duplication.
Okay, let me answer Comfort. Comfort says, what happens when a staff member is given a dismissal letter and then the staff comes back to say they want to submit a resignation letter? The deed has been done and the employee has been dismissed. There is no reason, nowhere stated in the clause or law that an employee can come back with a resignation letter. That employee is trying to do what we call damage control, because when you refer back to previous employer reference, your subjection to the company would be such person was dismissed from your employment. So that person wants to clean the book. So that is not done. So dismissal has been done. I feel if you follow the due process, there won't be any issue. Adeyemi Lanre, my question is, when it was stated in an employment letter that an employee can give 1 month notice of resignation, but suddenly there is a memo that an employee should give 3 months instead of 1 month written in the employment letter. In that case, what should the employee do? If I'm the employee, I think I'll be having 50 million naira in my account, let's say before 2026 close by, because that is what was agreed on initially, and that is what will stand in the court of law. So in the case where they want to bring in 3 months notice instead of the 1 month that was agreed on, please go ahead with your 1 month notice. If they do not follow due process, pay your 1 month in due, you can go ahead to file litigation through the industrial court, and they will take your case. It's a sweet case. You will be making more money based on damages, right? Let's look at other questions.
Paul. So it's just to widen that conversation a little. What if for good reasons the organization wants to expand 1 month notice to 3 months, and it will be both ways? So it also means that if the employer wants to lay off the staff or no longer need the services of the staff, they will now give 3 months notice. So not a one direction, two directions. Can they have a conversation and change the agreement, mutual agreement now?
It's dicey, because if you look at what the law states, it's looking for the origin of how the employee was recruited to the organization. So should you want to review the policy, it must be agreed by both parties, like you've said. But in most cases, employee wouldn't want to go through that route, because at the end of the day, it's just like you holding the employee for 3 months within the organization. And you would agree with me that most organizations, while joining them, you are given 3 month notice, and maybe your role is not even on the executive management, the CEO, the COO, the chief HRO. You do not hold that title. Those are the titles that would want to look at 3 months. When someone is an officer, a manager, I do not agree with 3 months notice period. I still feel that it's unlawful. It's a process to stifle the employee to remain stagnant in such environment. And I, for one, if I have a 3 month notice on my employment letter, I would not sign such letter, because what it means is that when I'm leaving, resigning the organization, I'll have to give 3 month notice. And believe you me, no employer would be taking 3 month notice as a junior staff or a middle level staff joining their own organization. So if you are going to give 3 month notice, it will be those who are on the upper level in your cadre of your organization, like group heads, C-suits, executive management, those who their roles, when they tend to leave, it becomes very difficult to even find a suitable candidate to recruit from. So I think that's my justification on that. It's not nice. It's just a means of trying to bond the employee within that organization. Okay, I have Vicky Star. I can see your hand. You have the floor.
Hi, good evening, Doctor. Good evening, Barrister Paul, if I'm allowed to say that. Thank you for this section. You took us back to the class. Okay, straight to my question. If you have should I say a staff, like this particular staff is on the A level, and she has never been caught Like when I mean caught, she's never had a query. She's always on top of her game. And a situation popped up, and the CEO of this organization is telling the HR to query the staff for the first time and given a suspension of 1 month to this staff. And the HR is trying to like defend the staff, investigated, and she was able to control the situation. But he is still insisting that she is being queried for 1 month. What do you do as an HR in this process? Thank you.
The first question I will ask you, what is within your disciplinary action or code of conduct? When you assign a query, what's next? By any point in time you miss any step in your disciplinary code of conduct, disciplinary guidelines, you flouted the process and it's unlawful, right? Naturally, when you query an employee based on, first question, is it a minor misconduct, right? If it's a minor, that means you question, you query, fair hearing, fantastic. If the situation comes back to be true that she did what had to be done, then the first thing in every policy I've seen, I've written, is first written warning. Then thereafter, if it happens again, it is final warning. And in the case of where it is now gross misconduct, it is dismissal. That is, you must have done your disciplinary engagement committee. They must have sat down on that case and agree. The two-thirds of the committee must agree on the next possible course of action. At no point would I say that is just, that is unlawful. And to advise you, I would want you to give your detailed documentation to the owner of the business, to the CEO, on why this is unlawful. You need to quote the NICN, you need to quote the labor law on these cases, right? So that's unlawful in the first case, to suspend an employee indefinitely, especially when you know. So what we are trying to say here is that when there's a gross misconduct, the law is not stating that you suspend. The law states that suspension is for investigation. And for the fact that you've investigated, hence you have to dismiss such employee. But in a case whereby the lady is vindicated, that means it's unlawful to suspend such individual. I do not understand why the CEO would want you to go on to suspend such individual. So I would still want you to rally back, discuss extensively on why this can come back to the organization. And over time, I've seen that we do this to employees that we believe that they don't have the resources, the manpower to rally around litigation. Because if the owner of a business is being filed for damages of 50 million, I do not believe that such situation would occur, resultantly, subsequently, after that must have happened. So that is unlawful, Vicky, and you would want to go back to the management to advise them. It's just for you to have your own clean slate, advising them on the things they need to do. I hope I've answered your question. I'll go on to Ali. You have the floor.
Yeah, good evening, everyone. It's been a very wonderful session, and this is really, really appreciated. So I wanted to go back to the question that someone asked today that has to do with an employee being dismissed and coming back to request for opportunity to resign. I think like you rightly explained, before a dismissal happened, there would have been queried and there would have been panel set up, investigations must have taken place, and the panel would have agreed that the penalty is outright dismissal. In that case, I don't even think the employee will have the guts to say he wants to come back for to allow being resigned. However, if it is a case of termination, which is not a dismissal, because I'm very sure that the person that asked that question, I'm not trying to preempt him or her anyway. I'm very sure that he is not limiting that question to dismissal alone. But when it has to do with termination, there are situations whereby, based on understanding, if maybe that employee has not committed anything bad, maybe it's because of performance or whatever, and in Nigeria here, we are always a kind of feeling that it is a kind of a stigmatization to say I was terminated, which of course is not a problem. One could be terminated for so many reasons, but in that case, it's okay. You may, based on understanding, you can, as an employee, you can come back to say, I want to resign. I've seen it happen in areas that I've worked before and all of that, and it played out very well. So that is just the clarification I want to give. Thank you.
Yeah, thank you very much, Aliyu. That is understandable. I would want to say that in major cases that has been in such situation, you look at maybe a performance framework where HR have seen that, this person is below performance, and the management had advised for termination of employment. I've seen so many times where HR professionals will just go and chip in an information to the employee to resign immediately, right? So yes, some environments, they have that mutual understanding. So, but for dismissal, it means that that person must have done something very huge to warrant dismissal. But if the question is valid through termination, of course, that can be looked into, that can be considered. If majorly you are looking at termination based on performance, or let's say maybe a redundancy within the organization. I've seen where people would do something wrong, or maybe the decision by the management is to terminate an employment. And of course, mutual understanding, they'll just, okay, you know what, just put in your resignation, we'll pay your 1 month salary in lieu, and so on. I have Kunle. You have the floor, sir.
All right. Thank you very much, Paul. And it's been a very insightful session. Thank you for being very detailed. I just want to lend voice to two things which have come up in the question and answer session. The first one being on the 3 months notice period. So by labor law, there's really no a specific number of period for notice period. Because if you look through the labor law now, you start seeing things like, if a person has worked for 1 year, the person is just meant to give like a 1 day notice before resigning. 2 years, I can't really remember the specifics, but you don't even have up to 2 weeks notice period by labor law. So what has happened over a period of time has been people using that discretion to specify periods, and what you generally see is 1 month notice period. Generally, that's what you see. However, for certain positions, higher ranking positions, and because of the sensitivity of those positions, let's say, for instance, your CFO, your head of treasury, your CPO, those top positions that head an entire unit, not just a department, now to say like an entire unit that is very, very crucial to you, companies have now started extending into 2 months to 3 months, that kind of long time of notice period. So the question that brought this conversation up about being, if all of a sudden during your employment, there is now a memo that says all employees are to start giving 3 months notice. So my advice to such a person would be go and have a conversation, especially based on your role. You have to look at what your role is and how crucial your role is to the organization, to go and have a conversation and say, I understand you want us to give a 3 months notice period. However, I do not think my role, maybe as an HR officer or even an operations associate, demands a 3 months notice period. Can we review to a lesser number of months? And if your appeal is not being heard, I will advise you to start looking out, because that memo, by virtue of that memo going out and you not immediately declaring your reservation for the memo, it has now become binding on you. especially if the HR in the organization sends out a kind of acknowledgement form and you either acknowledge or ignore the form, it is binding on you. That you do not sign it does not mean you will not give that 3 months notice. The law does not support you. Oh, I don't sign, that means I'm not giving the 3 months notice. No, you would have to. So, and also then the next thing is the question Vicky asks that, okay, a staff has been aired, wasn't aired for a long time, and then the MD is asking that the person goes on suspension. Like you rightly said during your presentation, you said, as HR, we are all advisors. We are there to advise the management on the best course of action. We will do our due diligence, our due process, that's give the query, take the person through the disciplinary committee. We will do all of that. However, if the MD now still insists on that person going on that suspension, there are 2 ways to handle it. I've been in that kind of situation where the MD insisted on the staff going on a 1 month suspension. So what I did in that situation was, the first thing I did was I just told him, yes, sir, and I left his presence. And I came back much later and I said, sir, can we have a conversation around this suspension? He said, okay, fine. What's your advice, HR? And I told him, sir, I understand that you are very angry at what she had done, and what she has done is very wrong. However, I do not feel that a 1 month suspension will work in this situation, because we're going to be sending the wrong message to this staff. And we would, if we're not very careful, we'll have a disinterested staff. So why don't we do it this way? We would suspend her, but not for 1 month. We will suspend her for 2 weeks, and we will still pay her. And then the end was like, why would I still pay her? I said, because while we're suspending her, by our handbook, by every labor law I've read, by every judgment I've seen, there's nothing backing us up. But we're going to suspend her for 2 weeks, and this is how we're going to play it to her. I'm going to be able to communicate this to her quite right, but this is how I'm going to play it to her. We just want you to take a time off, because we know you've not had an issue before in the entire company. We know you've not had issues. We know you've been an exemplary. So we just feel that something is going on, but you have not been able to tell us. So we just want you to take this time off to go and think about it, and be rest assured you are still getting paid for that period. So that was how I was able to handle that situation. My point here being, as HR, we are still also an employee. We are there to guide, we are there to advise. So we always have to apply emotional intelligence when handling our MDs and people we report to. We have to find that sweet spot that we can press to get what we need. We might not always be able to overturn the decision or the instruction from our MDs, but we can always get them to be more lenient and always find a better way to push what they want, in the sense of bringing it down and then also communicating it very well to the staff, so you don't have a staff that is dislodged. And for that staff that I was talking about, before she came back from our suspension, I had like 2 meetings with her during the whole suspension period. During the suspension and one, the day she was to come back. And in those 2 meetings, I kept reiterating the fact that, see, we value your inputs. It is just that extra work as HR. So I just thought to throw that in for those 2 questions. Otherwise, a very great job, Mr. Paul.
Thank you very much, Kuli. I think you've explained better. You need to also do what we call a rapport within the top level management, which is very important for our emotional intelligence. Sometimes when they make this decision, it's because they are reached. You know, when you approve payroll almost every month, you see what is being your debit from your account. So when they see employees do something wrong, so they are reached, and sometimes we just have to go back, liaise with them, let them have a basic understanding of what is happening. Based on your 3 months 3 months, what is it called, termination in lieu. So, like I said previously, I said the NICN itself does not stand alone, right? The labor law does not stand alone. They are referencing on something, which is the ILO. So the ILO is stating that the months in lieu must be agreed by both the employer and the employee. And the ILO gave a cap, right? It gives 30 to 90 days. So, right, so if you want to take it to litigation and say, oh, you are unlawfully placed to sign you signed the document. However, they will reference ILO stating that, okay, it's still lawful to place someone under 3 months probation. But again, like you said, it must be agreed on between both parties. Any further question? I have Omon Noah. I hope I'm correct. You have the floor.
Okay, good evening, everyone, and thank you for class. Please, I want to get this clarity. In a case where on the person's offer, it wasn't stated there that there will be an extension of probation period, but in the HRO handbook, you have it there stating how the probation period will go until you finally terminate if performance doesn't improve. What do you do in such a scenario?
So I would advise you take where it is stated in your handbook. You know, under offer letter, you see termination of employment, probationary period, right? Where you have the 3 months. Take it back to the offer letter where you have the signatory of that employee. So that means you are reviewing your offer letter based on the new normal of the jurisprudence by the industrial court. So the clause whereby it states that your probationary period might be increased from 1 month to 3 months, thereby at the end of the 3rd month, will terminate your employment, must be taken back to the offer of employment for correspondence. I believe I've been able to answer your question.
Yes, please. Thank you.
Yeah. Mr. Caleb, you have the floor.
Good evening. Thank you, Mr. Paul. I am very, very happy with what you said last time. So I have a quick question. Now, there's a staff that finished their internship, and after the internship, they're trying to promote the staff to a full-time staff. Is it okay for the staff to still go on with the normal probation period of time for by the company status? Is it like if the company is going on have 3 month probation after the before being confirmed as a full-time staff, is it going to be okay for her or she to go to continue with the full-time probation period, or after the internship that he has been confirmed, would they give in the information letter immediately after the internship?
Thank you very much for that question, Mr. Caleb. In every environment, there's what we call anyhowness, an open-ended environment. What is on your justification for conversion? So it means that during internship, such person might not be appraised, might not follow due process of your appraisal framework, and hence the environment would be, there'll be grudges of, oh, the intern knows the HR, the intern knows the CEO. So it's imperative for them to still go through the normal process of conversion. What if the person has interned in another organization and joining your organization? Would you say such employee has interned in other organization, there's no need to go through the probationary period? I can assure you that contract staff also still go through probationary period to just see their performance within the organization, because there's a mind shift of you were contract staff. The ratio, the weightage on a contract staff is different from the weightage on a full-time employment, right? They handle minimal task, while a full-time employee would handle strategic task or focus mainly on other departments, while they just focus mainly on internal departments of their organization. So it's different weightage, and we need to be observant of this. So I would advise that such intern would go through the normal probationary period to see the performance of such person before confirmation. Okay, I have Omoba. Last question will be taken for today.
Hello, good evening, everyone.
Good evening.
And thank you, Mr. Paul, for the delivery. I was in and out. The network is very bad, so I really didn't fully get into all of the presentation. But I just want to latch on to the question that the last person asked. But first of all, sir, you do not consider your interns or your contracts as staff. They are not really your staff, they are interns. And when they're doing their internship, they have their own guiding rules because the criteria of their internship for staffs to ensure that whatever it is that the intern has come for is achieved. So sometimes they have their own unique tasks that's been given to them, and they cannot really operate out of that task. And if they do, it's just for them to gain more knowledge, but they must achieve their own particular staffs. And like Paul said, you cannot take them as staff because the staff has their own appraisal, they have the job description, they have their targets, they have all sorts of things that has been given to them as proper staffs. And those milestones and the goals and all of those objectives, they must meet when the appraisals are being done. Whereas for the intern and even sometimes the contract staffs, it's not as deep for them. It's not as tedious. The things that are expected of them are not like the ones who want to migrate into becoming a staff. The first thing you do is to actually appraise them of how they performed as being interns before, or as being contracts before you can then consider them. Because sometimes you have interns, like Paul said, they're interning because they're the son of somebody who knows somebody that knows somebody. And so they're just there. And some of them will just loaf through because they know that, it's nothing, as soon as they finish, they go somewhere else. But some would really put their hearts to the job. And so those are the type that you may say you want to consider them, when you are, because sometimes it's easier for you to pull in someone who is already used to your organization, who's used to your ways, who knows all the things that you're doing and has put their hearts to the job. That means the person is reliable, is responsible, is ready to take on the role and all of that. So they will do all they can to ensure that they're a good fit. So they have to go through all of those things. They have to go through, if there's a test that you're giving to them, they have to go through all the tests. They have to prove themselves. Aside from proving themselves that they can apply, they also have to prove themselves that they can compete with other people that are also applying. So that's my take on it. Never see your interns or your contracts as your staff. They are interns and they are contracts. That's what they are. And they need to migrate properly into becoming staffs. Thank you.
Fantastic. Thank you very much for that addition. I believe you've said enough. So, ladies and gentlemen, I hand over to Doctor. Over to you, sir. You have the floor.
Thank you so much, Paul Okeshino. Thank you, everyone who have contributed tonight. Just one more thing that we need to do right now, which is to appreciate our erudite facilitator. Please let's unmute and let him hear our gratitude.
Thank you, Mr. Paul.
Thank you,
Mr.
Mr.
Paul.
Thank you so much,
Thank you
Mr.
so
Paul.
much.
Thank you
Thank
for
you.
an
Mr. Paul.
amazing and very
Thank you,
profound.
Mr.
Thank you,
Paul.
Mr. Paul.
Thank,
It's an
Aw,
amazing time.
thank you.
Thank
It
you.
was awesome.
Thank you
Thank
so
you,
much,
Mr.
Mr.
Paul.
Bell. Thank you,
Thank you,
Oh,
sir.
Mr.
Mr.
Paul, this was very
Paul.
thank
insightful.
you.
We love what
Thank
you
you,
do for
Mr.
us. Thank you so
Pearl.
much.
Thank you,
Thank
Mr. Bell.
Bye.
We appreciate your
Thank
time
you,
here. Thank you.
everyone.
Great job,
you,
Mr.
Mr. Paul.
Bell.
Thank you
Good
so
job.
much,
Thank you,
Mr.
Awesome.
Paul.
Mr.
Much thanks.
Paul.
Well
Much
Thank
done.
thanks.
you. Thank you so
Very
much.
insightful. Very, very insightful.
Very
Was very
insightful,
Very
very
insightful.
insightful.
impactful, amazing
So
session.
Thank you,
Thank
Mr. Paul.
you.
That was a
Thank you.
very
And
insightful
Thank
section.
you.
Very,
that,
very
that was
insightful,
an
Mr. Paul.
thank
amazing
you,
one.
sir.
Thank
Thank
you,
you
Mr.
so
Thank
much.
Paul.
you.
Mr. Paul. God
Thank you,
bless
Mr.
you.
Pearl.
Thank you,
Thank
Mr.
you.
Paul.
Thank you, Mr. Pearl.
Thank you, Mr. Paul.
Thank you, Mr. Paul. Thank you, sir. Have a wonderful night first.
Thank you,
Thank you,
Mr.
sir.
Paul, for a very insightful
Thank
session
you,
today.
Paul.
Thank you, Mr.
Thank
Paul.
you, Mr. Paul.
Thank
That was
you.
amazing.
Session. Thank you so
Thank
much.
you.
Thank you, Mr.
Thank
Paul.
you, Mr. Paul. Thank you.
Okay. Hmm?